Welcome into the roundtable, and AB 5 is back in the courtroom this week as we look at trying to see if that statute is going to stay within California law or if it's possibly going to be amended or perhaps even thrown out. Joining us to talk about it in terms of this courtroom drama again, we have Matt Leffler, the armchair attorney, joining us from Chicago, Illinois, and also Paul Torlina, Advocacy Counsel for OOIDA, also joining us here as well. Gentlemen, thanks so much for joining us. Matt, let me start with you. We're talking about the splitting of hairs here, defining what an independent contractor is. What's the argument here? Where do we need to find a delineation, and what needs to happen to make a case for those that are for or against AB 5?
Well, let's just do a quick little recap of where we've been and where we're at now. So this case started off in the district court. They lost. It went to the California Trucking Association, was litigating against AB 5, trying to knock it out. Went to the Ninth Circuit. They lost at the Ninth Circuit. They appealed to the Supreme Court of the United States, and the Supreme Court said no. The argument advanced by the California Trucking Association was really around this idea of F4 preemption. We talked about F4A quite a bit, but the reality is, like, this is back in the district court, and now we have some new people that are playing in the game. We have OOIDA who's come in, and they have a 4-count complaint, and again, they're trying to overturn AB 5. Some of the arguments they're advancing are the same arguments that have gone already, but there's some new ones around equal protection. There's some new ones around the dormant commerce clause, but we're still back in this fundamental question. Who is an employee? Who is a contractor? And what is the way in which you evaluate them? As of right now, AB 5 remains the law of the land, which again is just a codification of the actual case law in California with a case called Dynamex, which adopted this ABC test. So that's kind of where we are, and we're still in the same place we were a couple years ago, which is, does this law stand, and who will be able to hear it when it's all said and done?
Paul, kind of know what your stance is in terms of what AB 5 is, but kind of give us an overview of what the argument is that you would like to see heard by Judge Benitez.
The main argument I think that OOIDA is bringing to the table is that the exemptions that were carved out in AB 5, which apply to the construction industry trucking, don't necessarily apply to interstate trucking, and they're therefore discriminatory against every motor carrier or owner-operator who brings a load into the state of California as soon as they hit the state line. If they're not an employee of the carrier that they're driving for, they have a problem as an independent contractor and the owner-operator, because no one knows what's going to happen under AB 5 as far as enforcement goes when that driver comes in and does not either list himself as a motor carrier with his own authority or as an employee of the carrier that he's driving for. And as of right now, no owner-operator who is an independent contractor can qualify for any of the exemptions that are cut out of AB 5. And most specifically, they don't qualify for the construction industry trucking exemption. And if they're an interstate trucker, they cannot qualify for any of the business-to-business exemptions because they are also required to comply with the federal truth in lending requirements, truth in leasing, I misspoke, truth in leasing requirements. And that conflict in and of itself makes it to where an independent contractor owner operator can never comply with any of the B2B exemptions that AB 5 does offer.
Matt, of course, we got to say that you're not giving legal advice if you do in this particular case, but looking at it in terms of is that a legitimate argument, and if so, well, and broader picture, what are the landmines essentially in trying to create an argument that is going to essentially move AB 5 off of the law of the land if indeed those that don't want it are successful?
Yeah, I mean, the reality here is that this really hasn't changed the ability to be a business owner and operate a trucking company. I mean, the reality is, like, AB 5 has this preemption, is this idea of like presumption that if you're calling yourself an independent contractor, we're going to assume that you're probably an employee, and then you have to pass a 3-prong test. So that rebuttable presumption's pretty onerous, where a hiring entity has to come out and say, hey, look, I don't control them. This isn't my normal business. This person holds them out doing a bunch of different things. This has been like the litigation we've seen in California. It's been for decades. I mean, before we had the Dynamex case, we had Borrello. So the idea that this is like some weird esoteric thing I don't think is accurate. Now, the idea of the Commerce Clause is really interesting. So what happens with like Commerce Clause litigation is you have to say, look, there's a law that a state has made and it has this discriminatory impact on people from out of state. And we saw a Michigan case on like labeling animal products. And that was found to be not in violation because had Michigan said only other states' stuff that comes into our state has to have the labeling. So it ends up being the case where it's really not that necessary of a distinction. On the equal protection element, this is kind of interesting. So equal protection, essentially, and he brought up the good point on the construction side of things. When you talk about equal protection, it's about what level of scrutiny must you give the state? How much deference do you give to them when they make the determination how they classify things? And it's rational basis, which is the lowest threshold in our legal system for states to say, we believe it makes sense. And construction's a good example. Construction, generally speaking, is a very seasonal business. So a lot of people will hop in, do it for a bit, hop out. Very similar like snow plowing in like Illinois, for example. So the arguments that are being advanced, these are not really, in my opinion, very strong arguments. The F4A one was also made again by the OOIDA, and that was knocked down by the Ninth Circuit. This is, again, trying to tee up to get the Supreme Court to weigh in. I don't know that they will, but if you want to be a business owner and operate in California, you can certainly do that. Nothing about this prevents that. What this ABC test does is it looks at the factual, relationship between the hiring entity and the motor carrier, and they say, how much control do you have in all of this? So again, I don't think it's the end of the world, and I don't know necessarily that this is going to ultimately be successful for OOIDA or for the California Trucking Associations. These claims are okay, but the state has a lot of leeway when they make these types of distinctions.
Paul, as you look at the situation, obviously you don't want to see AB 5 on the books, but if that is not the case, what is the right scenario, in other words, in trying to classify independent contractors versus employees in terms of a trucking industry?
Well, classifying them as independent contractors versus employees it's a bit more complicated than just that question, because you can be an independent contractor as an owner-operator, or you can be an independent contractor as a motor carrier. And to say that this law doesn't affect owner operators in any way and they can still continue with their business model, I don't think that's 100% accurate. It does offer the possibility for an owner operator to go become a motor carrier in order to stay an independent contractor rather than becoming an employee. But that doesn't mean that they're operating under the same business model. There are more steps required to become a motor carrier. Not all owner operators want to become motor carriers. Not all of them want the responsibility. Not all of them really see themselves as the type of business person who can succeed as a motor carrier versus an owner operator. So this is a big disruption to their business as an owner operator who maybe leases on with a motor carrier. So initially to say that there's no disruption or no change and they can continue to operate in that independent contractor realm, while that's accurate, it's also more accurate to say that they do have to change their business model. They do have to incur additional costs and burdens to become a motor carrier in order to avoid becoming an employee. So obviously what OOIDA's standpoint is on that particular issue is we don't want to see that happen to our membership. We don't want to see that happen to any owner-operator driver, even if he's not a member or she's not a member. The freedom to exercise your entrepreneurial decisions and your business that you've put your sweat, equity, and labor into for possibly many years is suddenly being decided by a state that you don't live in or operate in, that you just can't do that anymore, whether you want to or not. So the obvious, quick, and dirty response to that is that makes zero sense. It's discriminatory. And under both the Commerce Clause and the Equal Protection Clause, it's unconstitutional to do to drivers who do not exist in California as a home base, yet they come into California to haul interstate loads.
And California certainly likes to be a trendsetter, that's for sure. Matt, Judge Roger Benitez is the judge in this particular case. He is the one that issued the temporary and the preliminary injunction. What's the significance of him being the judge in this case as well?
Oh, he's got the experience. In this case, gets remanded back to the district court. So once you get to the Ninth Circuit Court of Appeals and they say, hey, we're not going to allow this to go forward, you're going to have to go back to district court. That's where we're at. So we're back at the same court. It had to go back here. One thing to keep in mind is like how this gets enforced. So it's important to note that it's not the state of California walking into businesses and saying, okay, let me see your books, let me see your contractors, let me see your contract agreements you have with them. Typically, these things find themselves in litigation when some event happens. So let's say you're a hiring entity and you've wound down your business, you're slowing down, and you let go of a bunch of independent contractors, and those contractors try to file for unemployment or something, and they realize, oh, I'm actually not an employee. It's really about when someone finds out that they probably should have been classified as an employee, that we see the litigation and the lawsuits around classification stuff. So you can still come into the state of California, do your business. No one's going to come after you and sue you. It's really about when you have those drivers who have been classified incorrectly for a period of time, who have been injured or have some other thing that takes place, and then they jump in. So we're back at the district court. We'll find out really if this new injunction gets granted. There was an order that came out, but it hasn't been published on PACER yet, so I'm not sure if the injunction's been granted. But we're going to have the same kind of questions being asked. And equal protection claims, dormant commerce claims, these are kind of newer types of claims that are, I'd say, kitchen sink-esque. So throw whatever you can now and see what happens. The F4A claim that was, I think, count 2 of OOIDA's complaint, it's already been litigated, so we'll see if there's any real distinctions there ultimately. But this is the fight we've been having for decades in the state of California. Yeah. I mean, these companies have always had values of classification versus employees, and it's going to continue to be an issue for the foreseeable future. And ABC test is a test that's used in over 20 states right now, so that classification isn't like an aberration. There are other tests that could happen, but that's pretty interesting as it sits right now.
Real quick here, Paul. Obviously, this is going to be a fight that's happened before. It's going to be a fight that's happened again. If OOIDA were to lose this, will you continue to pursue the appeals and maybe even go to the Supreme Court again, or is this going to possibly be the end of the road?
I foresee that whoever is not successful in this case is going to appeal this to the Ninth Circuit. I think I think every side thinks that they have a good argument that should be granted by the judge at the district court level.
Okay. Well, we're going to have to leave it there, gentlemen. Thanks so much, and we'll see how this all pans out in that California District of Southern California there as well. Thanks so much for joining us.
Thank you.
All right, we'll take a short break and wrap up this edition of FreightWaves Now after this.